Four key factors emerged as a bone of contention during the four-day intensive Building Bridges Initiative appeal case hearing that concluded on Friday at the Court of Appeal. Our senior reporter Seth Olale highlights the core arguments presented by the four appellants in the case and which were responded to by a tyranny of civil rights groups opposing the appeal.
Right, Mr. Ngawa, you are...
The seven-judge bench of the appellate court, led by its president Daniel Musinga, which has retreated to draft its judgment on the BBI Appeal case, will be looking into four key arguments that stood out during the four-day hearing at the appellate court. They include the president's sovereignty and legitimacy in initiating a popular initiative, interference of the basic doctrine structure of the Constitution, IEBC's legitimacy in collecting and verifying signatures for a referendum, and public participation in a popular initiative. The appellants and respondents sharply differed on the President Uhuru Kenyatta's role in participating in a popular initiative as either an initiator or a supporter, and as a head of state or a private citizen. The five-judge High Court bench, during its landmark ruling, categorically stated that the President cannot be an initiator of a popular initiative such as the BBI.
If he wants to engage in the affairs of other lesser mortals, then he must abdicate.
And when you have a president who is not obeying court orders, when you have a president who is demeaning judges before the public, this court must stand firm and say to him, no.
Modern dictators, especially in Africa, are using the Constitution or constitutional amendments as a special purpose vehicle to claw away on civil liberties and democratic gains.
But the appellants argue that the president was removed from the process.
The judges did this through personalized attacks against His Excellency the President of the Republic of Kenya that climaxed in factually and legally unfounded conclusions.
On the issue of the basic doctrine structure, the pro-BBI team was of the view that the existing constitution gives room for amendments through a popular initiative. However, those against it in the case maintain that key pillars in the 2010 law cannot be changed.
There was never an intention to make certain parts of our constitution unamendable, because if that was the case, then the makers of our constitution would have expressly stated so in the constitution.
Then people say, if we can't change the constitution, surely we must overthrow it. That is a terrible thought, should never be allowed to take root.
The interested parties in the case also disagreed on IEBC's legitimacy in conducting a referendum in its current status.
There is no legislation governing the collection, verification, and presentation of signatures for a popular initiative.
While the appellants maintain that Wanjiku was involved in the entire BBI process, the respondents maintained that the BBI was a state project.
There are records of public participation or indications of public participation in nearly all the county assemblies and parliament.
All said, done and submitted. August 20th, 2021 is the day of reckoning. Seth Olale, NTV.